Good morning, friends. Let us learn AIBE sample question papers. Okay, about the Constitution. So, first question is the structure of Indian Constitution is which type of structure it is having means federal in form and unitary in spirit. This is the answer. There are four options are there, but I am going to give you only the right answer. And second question is in whose time period the panchayat were given the constitutional status? That who was the prime minister that time? It was P.V. Narasimha Rao. Okay. Next question is who described the part 3 of the Indian Constitution as a most criticized part of the Constitution? Which part? Part 3. Who said this? Dr. B.R. Ambedkar. Next. For which of the following special provision can be made under Article 15 of the Constitution of India? You are well aware Article 15 subclass 3 about the women and children. So special provision, special status is made for women and children under Article 15 subclass 3. Now let us move. Under which law the untouchability has been declared abolished in India? That is Constitution of India. Okay. If I am not wrong, it is I think Article 17. Now let us move. The Supreme Court has held in a case that Mrs. Sonia Gandhi, the President of Congress, is not an Italian citizen but is an Indian citizen under which act, that is the Citizenship Act 1955. So these are the some of the sample questions. Let us move again that Constitution is generally defined as what it is defined fundamental law of the land. Next question. Judgment under section 2 subclass 9 means its correct answer is statements of grounds of an order or decree. Now, which of the following is not a pleader? An advocate, an vakil, an attorney of high court, the recognized agent. So, recognized agent is not the pleader, he must be an advocate or vakil. Next, which of the following suit is not of a civil nature? There are four options. That suit relating to right of property, relating to right to worship, relating to taking out a religious procession. These are all the civil nature. Whereas the suit for recover of voluntary payment or offering. So this one is not in a civil nature. Next, there are some other options. So now I am concentrating on this much only. Let us move some of the sample questions. Some of the civil natures like in CPC you will move. Where two or more courts having the jurisdiction of a civil court under section 20 CPC is can be excluded by a clear agreement between the parties. When there is a two jurisdiction of the civil court, so such time any one of the court you can try the civil suit. Next, when a criminal procedure code come into existence, this question has been asked so many times, so you are very well aware. That is 1st April 1974. It was earlier CRPC. Now the BNSS. So it has came into July, as you are now aware about. The first information report of offence is cognizable and other is non-cognizable. The whole case shall be deemed to be if in one case the some offence are cognizable and some are non-cognizable means the which is to be tried means always cognizable is to be tried. Answer is cognizable cases. The metropolitan magistrate is equivalent to judicial magistrate of first class. Okay. For appointment of special public prosecutor, how many years of experience is required as a practicing advocate? Its answer is 10 years he must be practiced as an advocate. So next we will move to the some other questions. Which of the following sentence may be passed by the magistrate of second class? So there is a limit and for jurisdiction also limit, for passing of the sentence is also limit. That is up to the not exceeding 1 year. It was earlier. I think now not exceeding 3 years maybe. Please you go through it. Any police officer may not, without an order from the magistrate or without warrant, arrest any person. There are certain I think section 41 in CRPC, there are so many that clauses have been made that under what circumstance police can arrest without warrant, who has been concerned in any of the non-cognizable offenses, then police can arrest. Next, a person arrested by a public police officer may be kept in custody. It is, you are all know, 24 hours only. He should be kept immediately. He should be produced before the magistrate. No, which is not the main principle of underlying the law of evidence. That hearsay evidence, friends, you are all know that hearsay evidence must not be admitted. Section 154, I think you must be, please go through it. So some of questions are like there is some problems they have given and you have to go through it. If you study thoroughly, definitely you will be able to answer all the questions. The question is whether A was ravished the fact that shortly after the alleged rape, A made a complaint relating to the offense is a, it is a, whether it is a relevant fact or relevant conduct. We have to answer for this. There are four options. The correct one is relevant fact and showing the conduct. The plea of alibi is governed by which section of the evidence? It is very very important. Plea of alibi means claiming that at the time of incident he was not at that instance, he was not that place, he was somewhere else. So this one is known as a plea of alibi, section 11 of Evidence Act. So this question has been oftenly asked. Next is opinion of an expert is whether relevant but unsafe and conclusive proof, supportive and corroborative in nature. Its answer is relevant, but it cannot be thoroughly believed, but it is a supportive and corroborative in nature. Next question is the communication of a revocation as against the person who makes it is complete. When it will be complete? If communication of revocation is made means, and the correct answer is when it is put into a course of transmission so as to be out of a power of the person who makes it. When there is a revocation, if it is put into a transportation, ಅವರು ಆಲ್ರೆಡಿ ಅದನ್ನು ಮೂವ್ ಮಾಡಿಬಿಟ್ಟಿದ್ರೆ ಥ್ರೂ ಲೆಟರ್ ಆರ್ ಥ್ರೂ ಎನಿ ಅದರ್ ಕಮ್ಯುನಿಕೇಶನ್, ಇಫ್ ಇಟ್ ಹ್ಯಾಸ್ ಬೀನ್ dispersed, that means ಸೊ ಇನ್ನೊರು ಮುಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೂ ಕೂಡ ಇಟ್ ವಿಲ್ ಬಿ ಟ್ರೀಟೆಡ್ ಆಸ್ ದ ಕಮ್ಯುನಿಕೇಷನ್ ಆಫ್ ರಿವೋಕೇಶನ್ has to be out of the power of that person. If he has already signed means it was revoked. An agreement is, so contract act again. So it is mixed questions about all the subject. So contract section 10 of the contract act, you know very well. Every promise or every set of promises forming the consideration for each other is known as a agreement. Section 10 of contract act. Even for further we are moving means there shall not be, should be a major persons who is of a sound mind. They can be available. They can be made an contract without any coercion. Next, one more citation is there. The Carlyle and Carbolic Smoke Ball Company case is related to what? So it is offer to public and large. That is invitation to offer public at large. That case law is, it is famous British case law, Carlyle versus Carbolic Smoke Ball Company. Okay. Now let us move some other questions. Next question is, stop where repayment begins can be applied with respect to whose cases? Only minors only. Okay. Not the illness, not the lunatic or incapable person. It is applicable to minors. The agreement entered into by a minor, is it valid or void? Null and void. It is at the very beginning, it is a void agreement. There is a one citation, I think so, Mohari Bibi. Please you go through it, where it was clearly mentioned that agreement with the minor is null and void. Next question. When goods are displayed in a show window bearing a price tags, it indicates what it offer means. It is an invitation to offer, invitation to make offer. If you go through displays of every shops and wherever, it is a nothing but an just an invitation to offer. Next, what will be effect of mistake as to law in force in India or an agreement? It is a not voidable because effect of mistake as to law in force in India or in the agreement. So it is not voidable. It can be made valid through the by the other person. For example, next question is, A for a natural love and affection promises to give his son B rupees 1000. This is what? With a love and affection. It is not a contract. Due to non-fulfillment of technical requirement as a relevant for the agreement or contract. It is just an love and affection. If he is giving, it is not a contract. Next question regarding specific performance. The nature of the specific relief act is remedial in nature, protective in nature, a procedure law. What it is? The fourth option is all the above. Specific is a, of course, it is a remedial, protective, and procedure law. The basic of specific relief act is only to law of equity. Law of equity. It is a, for a civil wrong we are moving to specific relief act under law of equity. Next, specific relief act under the act could be in the form of, that is, rectification of instrument, declaratory decrees, and injunction. So for all these we can move specific relief act. Answer is all of the above. Next, specific relief under the act covers possession of immovable property only or covers possession of movable property only. As you are well aware, both movable and immovable can be possession can be uh, covered under this specific relief act. Now let us know some of the questions. A suit for recovery of possession under section 6 cannot be filed against the government. As you are all aware, against the government we cannot file a under section 6. Okay, there is separate provision against government how we have to file suit earlier. We have to in CPC 80 subclass 2 we have to give notice and we have to dispense before the court, then only we will get the whatever the interim orders. If the court deems, then it will be order, otherwise it will issue the uh, emergent notices. Okay, next, section 10 of the specific relief act provides the contract which can be specifically enforced. You are well aware section 10 what contracts can be agreement, what agreement can be a contract. So there are some points important that I already told you. Should be a minor, should be a sound mind, there should not be a coercion, and there should be offer or set of affairs, and there should be a promise with a valid consideration. So under such circumstances, specific relief, we want to enforce the specific relief act of section 10 very clearly says that the contracts which can be specifically enforced. Okay. Next question. Specific performance of part of a contract has been dealt with under which section? Of course, specific relief act is a part of the contract act. So section 12 of the specific relief act. So you go through the section 12 of the relief specific relief act, because contract is a mother of all the these are the laws that is specific transfer of property and some other laws where we are thinking about the contract or agreement means the mother of all these subject means the contract act is the main. Next, which section of the specific relief act provides for the rights of purchaser or lessee against the person with the imperfect title in respect of the immovable property? So, section 13 of the specific relief act. Next, the term offense means, now again we'll move to the criminal act, that is CRPC. The term offense means the thing made punishable by a penal code or a thing made punishable by a penal code or any special or any local law in certain case. The answer is both 1 and 2. Okay. Next, which of the following case is related to joint liability? So joint liability, jointly and severally, you are all aware about that. Whenever any transaction or contract is made on behalf of some other person, if there is somebody given the guarantee or surety, so it is whenever the it comes to the joint liability, the one important case law is there, that is Mehboob Shah versus Emperor regarding joint liability. So you kindly go through that citation. Okay. Now, irresistible impulse means what? Irresistible, this was the question. The answer is does not come under insanity. So, the person is not come under the insanity. It means irresistible impulse. Now, one example is there. A with the intention of murdering Z instigates B to give poison to Z. B, however, takes the poison himself. So A is guilty of abatement because A has instigated him. So he is the only punishable person for the offense of abatement. Now, next question is the relation of jurisprudence into general and practical jurisprudence is a who has said these words means the Salmon. Okay. Who defined jurisprudence as a part of history, a part of economic and sociology, a part of ethics and philosophy of life. Who said this? This one said by Redleaf. Redleaf. Okay. Now, next, move to another question. Who defined jurisprudence? No, again it was same. Redleaf, who defined a part of history, jurisprudence. Okay. Next, the astole of individualism was destined to become the founder of the state socialism. The above statement is Dicey refers to whom it was referred. It was referred by Bentham. So remember the author's name, Bentham. Next, arbitration is akin to. It will relate to some other laws. Which one? Like it is like similar to the panchayat. Okay. Next, which of the following is not the characteristics of arbitral proceeding? You might have all aware about how the arbitral proceeding is going on. There is a four options that quickness in a decision, simplicity of procedure, or a judicial proceeding, and involvement of arbitrator or non-interference in court till the arbitration award is made. So it is of a judicial proceeding. Next. So question was that which of the following is not the characteristic of the arbitral proceeding? Not. So you have to, while answering the question answers, you should be very much aware about the question and you should read carefully. The question is not characteristics the a judicial proceeding. So this is the answer. Now coming to next question is so very similar. An arbitration proceeding is a quasi judicial proceeding. So it is not a judicial proceeding, but it is a quasi judicial proceedings. Next, now which of the following is the mode of arbitration in existence today? Which type of existence? So online arbitration is there, fast track arbitration is there, ad hoc arbitration is there. So all type of arbitration are there. Answer is all the above. Now let us move to for the law of limitation, which is the incorrect statement. Incorrect statement. There are four statements here. I am going to read now. Bars the judicial remedy, does not extinguish substantive right, is an adjective or procedure law, creates a right in favor of the person. So, of course, the law of limitation creates the right in favor of person. Next question. Where no period is prescribed for the exercise of a power in statute like limitation act, such power must be exercised when there is a no time is fixed means within a reasonable time. So that time is to be considered. Next, option of puberty as a ground of divorce is available to the wife under dissolution of Muslim Marriage Act 1939 when the marriage has not been consumed. So option of puberty you might have know 15 years is earlier it was that granted to the woman to be allowed to be married. Now there is a one option that either puberty or else after the 15 years. So the when the marriage has not been consumed. So that was the option of puberty as a ground for divorce. Okay, she might be married but there is a marriage is not consumed. So next question. Acknowledgement of paternity cannot be made in respect of offerings. So in 7 such cases means incest or adultery or fornication. So these all under the all the above. Answer is all the above. Next, which of the following is the ground for declaring the marriage void under the Parsi Marriage and Divorce Act 1936? The answer is impotency. Of course, it is a ground for all the divorce cases. Even HM Hindu Marriage Act also it is one of the ground there. Injuria sine damnum relate to cases where there is a injuria sine damnum means a violation of legal right. Injuria sine damnum. Injury sign damages. So friend, let us I will conclude here only. Again I will go through the remaining questions in my next classes. Thank you.